Good morning. Good morning.
Morning.
How are we doing today?
Great.
Awesome. You don't have to be muted.
If I was any better, my name would be Al Stiles.
Oh, yeah, I'm sure. Awesome. Well, Michael Baird is going to jump on to our call, so I'm sure he'll be on any second. He's an attorney with
Kellum.
Thank you. It was like in my brain. Good morning, Bob.
Good morning, my friend.
Thanks for hosting again today.
Thanks for having me.
Thanks for having us. So today's topic is lawsuit contributors. Yay!
Yay, you're still breaking up, Kristen.
Oh, I guess I won't be talking today.
We'll just have to muddle through,
I know. I don't know what's wrong.
but you're worth it.
Kristen,
Yeah,
unplug your camera speakerphone and replug it back into the USB port.
Unplug my camera speakerphone?
Yeah, you know how you're looking at the camera? Is it in the screen or is it a?
No, it's in my laptop.
Okay.
Yeah. Bummer. Okay, so we're going to talk about lawsuit contributors so we don't get sued. Yay! All right. What would be one of the contributors for you to possibly get sued if you didn't do things correctly?
Not staying in your lane. Trying to play loan officer, trying to play appraiser, that sort of thing.
Trying to play attorney.
That's what I meant when I said appraiser.
Yeah. Don't be the attorney.
Yeah.
Speaking of attorneys, there's Mike.
What's all this now?
Hi, Mike.
Yay, Baird.
We're telling everybody not to be an attorney, just you, nobody else.
I tell that to everybody.
Yep. So do you find that agents will?
Newborn babies, don't be an attorney.
Yes, please. Yes, please. A reminder to all applicant staff, please, when you return to the lot, keep your car unlocked.
Can you, Bob?
So,
I can't mute. I don't have the capability here.
thanks, Tasha, for the reminder.
Hey, Deb. Okay, so Mike, do you find that agents say a lot of things to their clients that are more that attorneys should really be discussing with them more so than them? Like, do you find they get in trouble a lot from that, or?
I mean, they can, but I think people are really, really aware of it these days.
Mm-hmm.
I think people are really aware of, like, I think people are kind of scared.
Mm-hmm.
I think people are worried, about things, I guess. And it's a tough, that's kind of a tough way to live,
Yeah.
But I think that people are very aware of, I'm gonna sort of describe this far, and then I'll kind of like, and then I think people are comfortable saying, you know what, for that you probably want to talk to your attorney. That's what I've found for the most part. Every once in a while, every once in a while I see something in like an offer or something that is sort of like really aggressive in terms of terms that could potentially call into question some things like down the road.
Mm-hmm.
But I'd say for the most part, agents are pretty cognizant of when to sort of not give certain advice. Sometimes problems that people get themselves in, people get themselves in the problems when they're like trying to really sell the property,
Mm-hmm.
or when they don't have an understanding of something and they don't necessarily want to say, I don't know, or I can find out about the property, and then they sort of don't find out. But yeah, no, for the most part, I'd say agents are 99% of the time pretty careful.
Mm-hmm. Awesome. So we're going to circle back to that about the information on the property. So, this, what we're talking about now, would be like inadequate communication. So between the agents and the attorney, and not addressing problems or complaints. Those could be two. Does that make sense?
In terms of like an example, maybe. Is there a good example?
I don't know, you guys tell me. What would be an inadequate communication? I mean, I guess besides the fact, let's table the whole listing, not knowing the information stuff, because we'll get to that. But anything else that you have communication with your clients that could cause some problems?
I think, not, especially if you're working with your team of people, whether it's the appraiser and the lender, if you're not in communication with the other two parties, I think that's, you may be setting yourself up to overstep your bounds as a realtor, and maybe give some advice that you maybe shouldn't be giving. I think the other thing too, as far as communication goes, is as much as you can figure out should be in writing, right? And CCing the other parties too, because I'm sure that if I sent an email to a client overstepping my bounds, maybe with some advice on a P&S language, for example, and I CC'd Mike Baird on it, Mike would step in and say, either on the side or right there, reply all. That's a good idea, Bob, but let's refine that a little bit, I don't know. I think that's keeping everybody on the updated, I think, is really important.
Okay. How about not identifying yourself as like the owner of the property, as being the listing agent, or as an agent when you're purchasing a property from a client?
Yeah, I think that's definitely something that you want to be cognizant of. But getting back to the in writing piece that Bob talked about, that's, we all know, okay, it has to be in writing, right? Because of the statute of frauds. I won't get into the sort of why it has to be in writing, but there's something called the statute of frauds, which basically means, well, I said I'm not going to get into it, but I'm getting into it, right? There's something called the statute of frauds that says all matters having to do with buying and selling land or real estate have to be in writing. So there's like 5 or 6 contracts that won't be honored unless they're in writing. And that's why everything has to be in writing for a real estate deal. Well, yeah, we all get the offer in writing. We all get the P&S in writing. We all get certain things in writing, but then it can kind of dissipate, right? And so we sort of sometimes lose those details. And let's face it, we're all operating very fast and very remotely right now. So it's hard to make sure, the listing says that it's subject to sellers finding a suitable home, right? But it's not in the offer, and then we accept the offer, which takes precedent. Now do we have, and we saw the offer, we love the price, we love the time frame, we got excited and we accept it, but we don't mark it in the offer that it's subject to a seller finding suitable housing. So it's those little pieces that kind of get lost, and you sort of say, well, everyone sort of understood and everyone knows that it was part of the listing agreement. So then you start to have to like tap dance.
Right, because you don't know if the agents had a discussion about it, even though it was in MLS on the seller side. You don't know that the buyer agent and the seller agent, had a discussion and they said, oh no, we can drop that, it's fine. Yeah. Whether they even talked to the seller or not. And then here you go with it being signed and getting the person's purchase and sales. I mean, John just went through that on his first transaction. Yeah. It's like after purchase sales, oh, by the way, we have to find some way to go. Well, what do you mean? Yeah.
Doesn't it, doesn't the offer supersede anything else, even that was signed before? And then doesn't the P&S supersede the offer, Mike?
Yes. So it depends on the lawyer answer. It depends. If there's language in the P&S, there's standard language in the P&S that says this is the final agreement between the parties. No agreement before has precedent, and no agreement after has precedent. So that's sort of, but that language can be in there. I would say that there's an argument to be made that, if a term like that was in, say, the listing agreement, and then the offer doesn't have it in there, and then suddenly you run into an issue. And then let's say you're trying to put that term into the P&S, right? You're at the offer P&S stage. and you're trying to say, well, it's subject to the seller's, home sale contingency, and you say, well, the offer didn't accept that. I would, it depends on who I'm fighting for, right? But I would say that there's an argument to be made that contingency could get put in the PNS agreement. It's not a very strong argument though, because like you say, for the most part, that offer trumps the what's in MLS. I know that that's a shaky answer, but I think you would really fight to get that into the purchase and sale agreement, because once it's there, then it is the case. So.
Can I give a real life example?
Yeah.
So I had it's going to be actually a home that's going to be closing soon. The appraisal came in lower than the sale price, and the sellers agreed to lower the price. So this is after the PNS has been signed, and we actually drew up an addendum to the purchase and sale where all parties signed. So it's still valid PNS, correct?
Yep, perfectly acceptable. Yep.
Right.
That's the correct way to do it. Yep.
And is that something that you would recommend that an attorney would draw up, or is it okay for the real estate agent to draw up and run by the attorneys and have their clients sign it?
Either. I think either is okay. I would prefer to write it up, but if it's a seasoned agent and that's the only change that's being made, and you've got the magic words in there, I would say that it's a valid amendment.
Great.
Okay.
Sorry,
So
I didn't mean to come in late here and start yakking.
Oh, no, it's all good. No one can hear me anyway, so go on. So I have a bunch of bullet points here, so some of them kind of overlap. And I'm trying to keep on track when you guys talk, we'll kind of shift around. So lack of documentation. So it kind of coincides with what we just talked about. Give me some other examples of lack of documentation.
Missing lead certificate, a letter of compliance, and now the lead remediation company has gone out of business. We need an attorney for that one, I think.
What?
So the homeowner had the house de-leaded.
Yeah.
But they lost the certificate.
Oh.
The state doesn't have a record of it, and the de-leaded company went out of business. Yeah.
What happens in that case, Mike?
Yeah. I mean, I think you need to, no, it's not good. I mean, would the owner, be willing to, what is the inspection of that? Look, could you have a lead inspection, Donna?
I think we did not. This is a long time ago, Mike, but I'm pretty sure there was an affidavit that was done by an attorney, and that sufficed. But we definitely needed an attorney.
Yeah, no, I guess I would say it depends on what the parties are comfortable with. If the buyer is, if the kid gets lead poisoning, you can't then hold up the piece of paper and say, well, we had this piece of paper, the kid shouldn't have lead poisoning, but yeah. But yeah, I mean, if it depends on what just in terms of moving forward, what the parties are comfortable with, you got the lender and the buyer. So.
Is the lender always made aware of missing documentation like that? I don't think we shared that with anybody.
Yeah. No, I don't think they are. I mean, okay. It depends. There's certain things the lender needs and certain things that the lender doesn't really care about. And in that case, it comes down to the buyer. Let's say you've got like a fence encroachment, right? If it's like a minor little fence encroachment, and then the buyer is willing to buy the property in that condition, I don't think the lender really cares. See Sam saying no. If it's like a building permit thing, again, and the buyer is willing to accept the property in that condition, I don't know that the lender really cares.
Okay. What other lack of documentation? Come on, guys, this one's the easy one.
Oof.
Melissa, where are you?
Okay, I'm here.
Here we go.
Just reached for my microphone. So
here comes the list. Get your papers out.
So, I mean, if I can just back up to the beginning in terms of process, I think, I know, Bob Malone, I know you do this. You go through the same process every time when you talk with clients. So it's, you know, it's a form, it's a pattern, and you don't want it to sound canned, but, you know, it's a form and it's a pattern, so that when you take a listing or when you're working with a buyer in particular, you should just have a series of questions that you ask so that you know, if this was my first listing of the year or my 20th listing of the year, I've gone through the same process. So as far as, you know, lack of documentation goes, there's so many landmines that are out there. So if you just have your list of asking all the questions, the chances of you're missing something are reduced, not guaranteed, but certainly reduced. Are you on town water or do you have a septic system? Always check that with the town. That's important, especially in towns where there's a combination of some are on septic and some are on town sewer. Do you have a well or are you on public water supply? Are you up to date on those bills? Like that should be your clue of, oh, if they're not paying a water and sewer bill, then maybe they don't have, maybe they have private water and they're just not aware of it, or, you know, something like that. Ask about, you know, have you filed for bankruptcy? Are you current on your mortgages? Have you received a foreclosure notice? Things like that. Let's see, what else? Have you filled in a swimming pool? Have you tested the home for lead? Do you have a generator? Do you have an irrigation system? Things like that. I mean, they're not necessarily all of these, you know, area for lawsuit, but the more you learn about the property, then the more you can disclose or accurately reply to if those questions are asked of you, especially as the list agent. It's really important to know what's going on, you know, eminent domain wise in the neighborhood. If there's any road construction, maybe roads are being widened, are there utility easements, like that. So sometimes it's a good idea to look at the deed, at the registry of deeds, to see if there's anything mentioned on the deed. Oh, and one really big one too, which is kind of simple, and I'll bet none of us do. I might on occasion, if I'm just clued in, looking at the deed, you figure out who owns the property. Because you might be working with who you think are the sellers, yet they have no authority to sell the property whatsoever. And then you get a real big problem. Because then you have people who entered into a contract who don't have the authority to sell the property.
And that just happened with Bill Stone, Melissa. Did he tell you about that?
Yes.
He had a brother call him and wanted to list his sister's property, but the sister was, you know, unable to make decisions. And
Right.
it's like, you can't do that. She doesn't own the property.
Right.
You know what I mean? Like, so it's tough.
Right.
I mean, sometimes, you know, especially if you don't have a lot of business going on, and you're like, well, it's the relative, or it's this, it's, you know, the husband says it's okay, or the wife says it's okay. And, you know, we come from, you know, scarcity and wanting that commission. You know, sometimes people make bad decisions on doing things like that. And that's going to get you in a lot of trouble.
Right. Absolutely.
Hey,
Absolutely.
Melissa.
I'm sorry to interrupt. Oh,
No, it's okay, Margaret. Go ahead.
good. So those are all great questions, and there's definitely a few in there that I didn't think of. Do you have a list, or, you know, do you bring something with you that you could share?
I can.
Oh.
Yep. And I do. You know, I have I have something that I usually print out when at least I used to meet sellers in person every time. But generally, it's kind of like ingrained in my brain now. So I think of them that way. But yeah, I do have most of them written down. Yep.
Oh, that would be great. Thank you.
Thank you, Margaret.
Hey, Melissa, I got a question for you. What relevance would it be if a seller was claimed bankruptcy?
Because they may not have, yeah, that's a Mike Baird question. They might not be able to authority to sell yet. Go ahead, Mike.
No, because if a seller claims bankruptcy, Dennis, sometimes they get there's a lien on all their property sometimes. So like if you declare bankruptcy, then your debtors have a representative at that bankruptcy court in the form of a bankruptcy trustee. So the bankruptcy trustee now represents your credit card, you know, debt, your child support debt, like whatever it is, and they can have an interest in all of your assets, including any real estate that you own. So if what you need to get is a like a release from the trustees, you know, from the bankruptcy trustee to say, you know, I'm going to allow the sale of this property to a third party. You can get, or to say, you know, we're not going to go after this property at all. It can get sold. So it's a bank. So like anytime I do a title review, I always run the seller's name in the bankruptcy like if I'm representing a buyer, I always run the seller's name in the bankruptcy court to see if they did declared bankruptcy, because you have to get a release of it.
Wow, that's great information. I had no idea about that.
Yeah, it's definitely, no, she's got a great list going. I want to hear more of it.
Well, and the reason why I think about the bankruptcy thing is honestly because it happened to me. You know, it happened to buyers I was representing. The seller was the broker of record for the real estate company and the seller, and never disclosed that he had filed bankruptcy 18 months earlier in order to try to protect himself from a divorce. So he never disclosed it. He knew he had to, and then he backpedaled, and you know, it was ugly for my clients, because then, you know, then they're homeless, they've moved out, their things are in storage, you know, the typical sort of worst case scenario story. And you know, also I'm not ashamed to say that in my 19 years I've been sued once. And unfortunately, that one lawsuit was my first real estate transaction in my first year. And the only, and you all know how compliant I am, and the only consolation I had was that I hadn't missed anything and I hadn't done anything wrong. So it didn't matter who the listing agent was, the outcome was still going to be the same. It was a very unusual situation in Quincy where a house had been moved. It had been moved I think 1.5 miles, and it sat on its new foundation. And at the time, it was sitting on a farm, and then the Southeast Expressway went through. So there was the Southeast Expressway in the backyard, and the off-ramp in the front yard, and the rotary in the side yard. So the parcel had gotten smaller and smaller, and somehow the city had never connected that home to town sewer. Yet the family had been paying water and sewer charges since the 1950s. So needless to say, you know, everybody got sued in that case. The home had been occupied by one elderly woman who'd gone on to a nursing home and needed to sell the home to pay for her care. And all of a sudden there were 5 adults living in the house. So very quickly there was septic backup. And the town came out and verified, oh, look at that. It's just emptying into this concrete chamber in the backyard. So, you know, everybody got sued, and the city had represented that it was connected to town sewer and town water. So it was ugly, and it went on for a really long time. It was one of the worst experiences I've ever had, but only because I was working for a broker at the time who didn't have appropriate E&O insurance. So luckily we have that at our KW offices. So.
Yep. And sometimes you can get wrapped up into a lawsuit when you've done nothing wrong.
Right.
It's like they're just going to name everybody because wherever they can get the money from, they will. Right. But it's all, and with that said, it's also important that you do make sure that everything is, you know, done properly. With the documentation, I was immediately thinking, you know, agency. How are you representing this person? Because that's been a situation before when, you know, if you don't have that mandatory relationship disclosure signed, and maybe you have a buyer coming in, and do you represent the buyer, the seller, or how is that, you know, filled out? So that could cause an issue too.
I think that's a large area for liability, from what I understand, that there are, you know, like of the top 3 reasons why agents get sued, one of them is about confusion of representation, and the second one is history of water in the basement, like things like that.
Yep.
My guess is that the third would be whether or not it's a single family, a multi-family. I have seen more problems with that, where agents will look at the public record, which is on MLS, which is coming from the tax assessor's office, and perhaps is not correct.
Right.
I was just about to say that if you've got, especially let's say a 3-family, you look at public record, 3-family, but it's not, because if you go to the building department, which is where the buck stops, you check the building department, it's a 2-family, or a 4, you think it's a 4 and it's a 3, and you can get sued over that, obviously.
Or it's a 2, Al, when you're in there, it's a 2. I mean, the public record says 2, but when you go to the house, there's an illegal 3rd, and the listing agent puts 3.
That's what I'm, well, that may not show up in public record, but don't trust the public record like Donna says, because here's the thing, guys. If you get sued, most likely I'm going to get hauled in with you. I don't want to get hauled in with you.
I actually have a follow-up question there, Al. You said that the building department is sort of like the end all be all. Is Is that the case? Whatever the building department has it there, or is it the assessor's office, or do they work hand in hand?
They don't. I mean, they should be. You'd
Yeah,
think
I
they
know.
would be, but
Yeah.
it's the building department has the certificate, it's in the file,
Mhm.
and that's where the buck stops. That's what it really is. And I went through a situation where the agent did not check, and we went through hell. I went through jury selection, the whole bit, all the way down to the verdict. And we happened to prevail, and they ruled that it wasn't the obligation of the agent. But you know something? That's not the point. If the whole thing is preventing from getting sued, it's not a question of whether you win or not. Because I felt like we lost, even though we won.
Yeah.
And I
Yeah.
don't think the agent felt any better either.
Yeah.
So the whole thing is just checking with, all they had to do was check, they would have found the problem, and that would have ended that.
Yeah.
So it's all about prevention. And there can be small things you can do to prevent big things from happening.
And that does happen a lot. We have access to, when we do refinances, so we see a lot of different properties, and, people might own a house for, 10 years, and then they come to us to refinance, and the appraiser, does check that, and it's not a 3-family, it's a 2-family. It really happens. I'm not going to say it happens all the time, but it happens quite often. And along these same lines, legal in-laws as well, right? I own a split, and I throw my, mother downstairs, I give her a stove, and I have an in-law, right? But if I think I'm buying an in-law, we really want to check to make sure it's a legal in-law.
Yeah, I mean, there are some towns that don't allow that, or they allow it only for a certain square footage percentage of the house. So like there are some towns that don't allow an in-law at all, or, it has to be a certain size. So like, then let's say if that's, if mom's paying rent, right? And, you've got to qualify, if that goes towards your income of how much, you're earning to qualify for, income wise for your loan, that could be, that could be an issue.
Or it may not pass from one entity to the next. You want to just check with the town, say, here's what, if you have any doubt, you just check with the town and ask them.
Yeah. Yeah.
Yeah, because I know in Marshfield, there's a thing called an accessory apartment.
Yep.
Not an in-law, but it's an accessory apartment, which is different.
I find as well that certain towns, you may find more hurdles in certain towns for certain things with regard to incomplete records. I had an issue with an in-law in Stoughton back in the spring, and it turns out that some of Stoughton's files for a decade in the late 80s, early 90s, a lot of their files are not complete due to an issue that they had with one of their inspectors who was relieved of duty. So the fact that I had gone through the file myself, questioning whether or not the in-law was actually legal, I went through every page. I took pictures with my phone of anything that I found relevant. And when the building inspector had come out several weeks later to do an inspection, he couldn't even find the paperwork that I had a picture of. So needless to say, that was a big old red flag, and I don't want to throw Stoughton under the bus, but you just never know. Are there other inspections going on? Are there other questions? Because the buyer was questioning, had maybe an inspector or someone at the town hall removed paperwork and just didn't put, a removal slip, or I don't know. But anyway, I had a picture of it, so that saved us in that case. And also the town of Rockland can be difficult as well, because Rockland, they did have a fire in, I think it was like the late 70s, the early 80s, where, the town hall was firebombed and everything burned down, and they lost all the records. And I think Barnstable County has had a fire too, but that was more than 100 years ago. So sometimes, you'll see patterns as you go into and through different towns, that some towns have hurdles and others not.
The Pembroke Town Hall had a fire. It burned down. Everything was gone.
So records lost there as well. What can they tell you if they don't have what you're looking for? They don't have what you're looking for. So that puts us in the lurch. But I always subscribe to the philosophy of, look, if I ever have a question and I want to represent it, whether it's over, disclosing lead paint testing or what's in hand for that, or, how to disclose to potential buyers, there's been some mold remediation here, I always defer to my client's attorney, because ultimately I'm going to follow the attorney's instruction as to how the best route looks for proper disclosure for liability reasons.
Yeah, I mean, the trend in terms of 93A, and Al, you can probably speak to this as well. The trend in terms of 93A is, you know, disclose, disclose, disclose. So
Yeah.
the seller is not subject to 93A because the seller is not a, you know, a business, but an agent is. And so, you know, sort of the rule. So if a seller doesn't have certain duty to disclose, but an agent does if they know. And now you get into things, and now the trend is toward things that an agent should know. You know, like I had a buyer who wanted to sue an agent because he was told that the storage for in a condo that he bought was in the basement, but it was really in the attic of the unit. And he, you know, it was like he had firewood and he wanted to store the firewood in the basement and not in the attic. So he wanted to sue the agent for the difference in value of a condo that had storage in one place versus another.
Oh.
You know, and I told him I wasn't going to represent him. I don't do litigation. A, B, I don't sue agents, but I mean, that would be, you know, so it's something as simple as that, where the agent probably took a guess and didn't know.
Melissa, can I go back to your due diligence at town hall? So besides the building department to check if there's any open permits, the tax assessor's office to check whatever you need there, and then the Board of Health to see if the home is on town sewer or if it's on a septic system, where else in the town hall would you go to do your due diligence?
That's it, really.
Okay.
Unless maybe there isn't a great assessor's record of, you know, some sort of an outline of the parcel, and we can't rely on assessor's parcel maps. We can only rely on an instrument survey. Sometimes you can go over to engineering and they might have a great plat laid out. That seems to be pretty common in like the 60s and the 50s and the 40s when neighborhood planning became more of a trend. I find sometimes the engineering department can be really helpful. And actually where engineering can also be really helpful is routes of like easements for water lines, sewer lines, drainage, utilities, underground utilities, things like that.
Do you check for betterments?
You know, I don't, not as part of my usual, unless it's one of those towns where I know that connection is either optional or recent, like Holbrook, Abington, Situate.
That's a potential source of tension down the road between the parties, because if you've done, like, as part of the title search, you know, you'll pull up a betterment or it'll either come through on a municipal lien certificate or as part of a title search. And now, you know, if the betterment is included in the buyer's taxes moving forward, or if the agreement in the purchase and sale agreement says the seller's going to pay the betterment in full before they move forward, you know, you could be paying off $6,000-8,000 in the betterment charge, as opposed to just rolling it into your taxes, you know, moving forward. So they should have a record at either the assessor's office or the tax collector's office if there are any betterments in place.
Yeah,
Hey, Mike, because I don't want to, I don't want to act as an attorney. Can you give a definition of a betterment?
Yeah, a betterment. I can give an example. A betterment is like if the town connected a bunch of houses to town sewer, and that connection costs like $20,000 per house, then the town can better put a lien on the house for that 20 grand, basically house the payment into their tax payment and then pay it off over time. So it's so that's the way that a betterment can work, but it's a lien that the town puts on like a bunch of houses for one like collective action, call it.
I've got a question for you on the betterment. Can you opt out of it? Because I know there's been a number of betterments on the cliffs in Situate. And if you have your own tight tank or septic, do you have to accept that $30,000 betterment?
That I don't know. I would have to find that out, Brad. I haven't seen an example of it. So I get it further on down the road when the betterment's put in place. That's when I see it. I don't see it when it's first proposed. But I honestly don't have a solid answer to that question. Yes or no. I would assume no, because just from what I've seen, I've never heard anyone say, yeah, I don't want to do that. You know, because if the town's if they're gonna sewer the whole area, then they'll sewer the whole area.
Yeah. Interesting point we had on a property in Situate talking about betterments where the town insisted through an order of conditions that we replace a sewer pipe that was on our property but went across the road onto somebody else's property. We said, we can't do that. We can't go under the road because we don't own it. And of course they have road closure October 15th, so you can't do anything for 6 or 8 months. And then we can't traipse over a neighbor's lawn and demand that we're going to dig up their lawn to put a pipe in, a crushed pipe from the 19 whatevers. So as it turned out, we did a workaround, and we did a mitigation payment. The town of Situate accepted that to go plant some trees in some other part of town. So there's always a workaround, I've found anyway, in my short life. Money solves a lot of issues.
Mitigation.
Yeah. Hey, Mike, can you talk a little bit about zoning as well? I'm thinking back to that case, and I think it was here in Norwell, that was sort of groundbreaking.
Can I just jump in on that for a second? Can you guys hear me? Hello?
Yes.
Yeah.
Okay. Quinlan versus Clasby is a zoning case that you can look up. That was where the realtor was sued about zoning. And that's when it came out to say that it was not the responsibility of agents. So that was I think that's the case that you are potentially thinking about, Donna.
Is that the one here in Norwell with the
No, it's in South Boston. It was a multifamily.
Okay.
But it's a good case to look up. But I had well, John, go ahead and what you guys want to say, but then I want to ask you guys something about something that was on a forum in Marshfield about, what a realtor should know, where I think this was actually I don't even think there was an agent involved, but everyone seemed to want to go in and blame an agent for what happened to this guy.
No, you go ahead, Karen. Go ahead.
Okay, so I'm going to read you this thing. A guy wrote, I took a screenshot because I was actually going to bring it up to you this week, John. Just purchased a home we plan to renovate on Foster Ave, but I was unaware that we would have to raise the home if we do renovations, greater than 50% of the value of the actual structure. Just the home itself and not the land value. So a lot of agents I know, though, that don't even know that piece of information there. So he was just looking for recommendations of contractors familiar with the process. So people came back and said, well, didn't your agent disclose that it was in a flood zone? I'm sure the guy knew it was in a flood zone because Foster Ave is right in the water in Marshfield. So I don't even think that was the issue. I think the more of the issue was about the 50% of the value. But it's interesting. There's 89 comments when I last looked at it, but everyone went right to the agent being like, didn't your agent disclose? And like I said, I think it was based on looking it up. I think it was an off-market deal. So I guess in that situation, most agents don't know about the whole 50% of the value of actual structure, and about those, so where's the buck stop in terms of, what an agent's supposed to know and not know?
Karen, can you go back to the 50% of the actual structure? What do you mean by that?
So because FEMA got involved in it, they had to do, when you're doing renovations on a home, and if it's greater than 50% of the value of the actual structure, then you have to bring
the improvement. Okay, got it.
Then you have to bring it up to code. So a lot of people, the way they get around it is they'll do it in steps. So they don't, so if they're buying a house that needs, multi-million dollars worth of renovations or what have you, they may do it in steps. I mean, obviously, if you're in that price range, then you're not doing it in steps because it's not a big deal for you. But for other people, the normal, regular person that's doing renovations, it can be a big deal. So they do it in steps to avoid that. But a lot of people don't realize that. So
I mean,
they're trying to
I saw that post too, Karen. I didn't really weigh in on it, but I did think it was interesting. I mean, everyone always wants to blame the agent, right? But I mean, first of all, which agent has the duty to disclose that? Is it going to be the listing agent? Who are they purporting has the? I mean, okay, as an agent, you can say this house is zoned R1, right? Or it's pre-existing non-conforming or something, and we can kind of talk about that. But you know, does an agent have to anticipate what a buyer is going to want to do with the property and sort of weigh out every single, you know, possible permutation and say, well, you can do this, but not that. Or if you do this, you're going to have to run into that. I mean, at some point, the buyer has to have some responsibility here, I would say. And the buyer's agent, I mean, can look into, you know, the house exists legally right now for what they're using it for and the parameters that it's used for. Like, you know, the house isn't a, if it's 10,000, if it's supposed to be 10,000 feet, or 10,000, if it's supposed to be 10 feet from the boundary line and it's new construction and the builder built it 5 feet from the boundary line, yeah, that's something that an agent should notice. But if I'm going to buy a house and knock it down, right, and I don't tell my agent that, and then I run into this hurdle at the building department, you know, to what extent does the agent have to anticipate all those different things? I mean, the only thing that I do with someone is if I see a limitation in like a Title V, if the Title V is limited to 3 bedrooms and there's a deed restriction, sometimes the Board of Health will require a deed restriction that says you can never build more than three bedrooms in this house. I'll then call the buyer and say, hey, listen, if you were going to add a 4th bedroom, you're not going to be able to do it. You know, so that's sort of something. But in terms of anticipating what a buyer is going to do, I mean, what do we do? You know?
Yeah, I think, well, that's the whole thing. I think, you know, I've dealt with different buyers along the way that have been looking to build things.
Yeah.
And I usually refer them. You know, it was one situation, they're looking at a piece of land and it was not selling in Marshfield. Well, you know, I started doing my due diligence for them. Like, I said, it's a lot bigger than you think it is. You need to actually improve the road.
Yeah.
You want to actually build on this. And I go, nah, that's why it's not selling. It's going to be cost prohibitive for most people. But so most times what I'm just trying to tell my people, I'm like, you need a builder in here. I can give you setbacks and all of this and go, but I'm not a builder. And there could be conservation issues. There could be a lot of other issues that I'm not going to know about. So
even a civil engineer knows that stuff. Even a civil engineer is real familiar with the local zoning.
Exactly.
Yeah.
So that's what I do. I refer them out to these people because I'm like, you know, I'm not going to say you can do anything here because how do I actually know?
Yeah.
Right. Because Susie next door may not want you to build anything and she's going to be down there and she's going to slap, you know, you're a butter who's not going to sign off on it.
Yep.
Hey, Mike.
Yeah.
In your example, I'm assuming, and my knowledge base would tell me that a seller would need to disclose if their property's in a flood zone, and then the buyer's going to have to do their due diligence and talk with civil engineers. Because, I mean, correct? I mean, in this particular case in Marshfield, that was my, that's what I drew from it, in that somebody didn't disclose something, and then it triggered, okay, now you can't build better than 50%, now there's a problem. So that would be the proper protocol, right, for the seller in that particular.
I don't think the seller has a duty to disclose that. I would say that's something that so okay, here's sort of the differentiation. I would say that, I mean, I would say being in a flood zone is something the listing agent should know.
Absolutely.
I don't think that they need to know the nuances of the building code for building in anticipation of the buyer doing something. I think the buyer's lender is going to want to know, and I think that the buyer should also look into it, you know, to figure out if they're in a flood zone. But to answer your question directly, I don't think it's the seller's duty to disclose that they're in a flood zone. The buyer can certainly discover it. Wow,
because there's 20 different types of flood zones, you know, so
yeah,
especially in Marshfield. So would, if somebody gets sued in that and they didn't disclose it, I think it would be the listing agent.
I think you're right, because I tend to sort of advise away from sellers filling in those disclosure forms, like those standard disclosure forms, like, you know, with a million things. Yeah.
Yeah, agreed.
Mike, why is that? Sorry, just to jump in, I'm curious, just because I have some personal experience with the whole flood zone not being disclosed, and then even there's disclosure, just because I'm a fairly new agent and I'm having my first listing next month, and I actually was going to have the seller fill out the disclosure, but I've heard mixed reviews about it. So I was just curious to hear a little bit more about that.
I mean, it's becoming such a slippery slope for sellers to fill that stuff out. And a lot of it is stuff that the buyers, you know, ought to be able to find. I don't think they should hide it. You know, there's language in the purchase and sale agreement. Like if I'm representing a buyer and they put forward that standard paragraph that says the seller has made no representations that the buyer is relying on. If they filled out that disclosure form, they have made representations that the buyer is relying on. And where there's no duty for them to disclose certain things, now they have. And even if they don't know, I mean, if you want to have them fill it out as a matter of practice, that's fine. Just make sure they're not lying. Most of it says, you know, to the best of their knowledge and stuff like that. But, you know, they have made a representation that the buyer is now relying on.
Yeah. And I am familiar with the case where the agent filled that out on behalf of the adorable little old lady seller and didn't fill it out correctly. And that liability went back to that agent, and that agent and the brokerage were sued.
Yeah.
And so that brokerage does not do seller statements anymore.
And there is a form in .loop that'll make that you can have your client sign saying that they waive the that disclosure.
Oh,
Yeah.
okay.
So be sure to have that filled out and signed.
I always give them the option of either or, and if they're not going to return that disclosure to me right away, which is very rare that they elect, at least my clients, that they elect to fill that out, I just get that decline form right away, and I ask them, you know, please go over this form with your attorney, and if your attorney advises you to complete it and return it, no problem, I'll post it and we'll use it. But let's instead just prepare for any questions that buyers may have, and we'll just answer them honestly and openly. And generally, I'm finding that, you know, sellers typically don't want to fill out that form. So
Yeah.
it's easy to get around it.
How do you guys feel about, we've talked about this a little bit in prior weeks, but condo docs, and really where does the, you know, a lot of times buyers don't even look at the condo docs before they're making their offer. I think a lot of times too, buyers don't even look at the condo docs through the entire process. They have no idea what the condo docs are, and especially how important, you know, the bylaws are. And Mike, I can't imagine that we'd ever want realtors or lenders to review condo docs with a buyer. But if you're representing both the lender and the buyer, you know, you're doing the buyer's rep side too. Are condo docs something that you'll typically go over with the buyer, and even the budget and why that's important, you know, that sort of stuff?
What I do is I check to make sure that they're complying with the statute. And if the condo docs are compliant with the statute, all I really point out to a buyer is I'll highlight those rules and regs, the ones to say, you know, you can't have a dog more than 25 pounds, you can't have a flag hanging other than the American flag, which is one I've seen. You can't have commercial vehicles, you can't have, you know, name it, right?
Yeah.
I highlight those rules and I send them to the buyer and I say, look, you know, if you like the way the place looks now, just keep it looking that way. And that's usually the extent of it. And for the most part, the buyers are aware of this. This is actually something that I've seen agents do a good job of, is getting to know.
You sound surprised. Whoa. You sound really surprised.
No, not at all.
Anybody else notice that little inflection? Wow. Okay, keep going, Mike.
This is something that agents, I think, have done an excellent job of over the years. How's that? Better?
Oh, I love it. Yeah, perfect.
Is sort of letting the people, like most times a buyer will say, oh yeah, I know that. Like they sort of know the rules of that. I'll check for parking. I'll check for storage, stuff that's going to impact their actual life. But for the most part, I go through, you know, and just make sure that they're compliant with the statute. I'll have to say I don't review the budget. I guess I leave that to the lender. Is that not something the lender looks at to make sure the place is solvent?
Yeah, I would say that's something that we look at for sure, on a full review. But chances are pretty good that if you're going conventional, 10% down, and have a decent credit score, we don't require it at all. You know.
Okay.
And what about future assessments too, right? along those same lines. If I buy a house and the next day I'm getting my welcome to the condo association, template sent to me along with a notice that I have been assessed an extra 200 grand to be paid over the next 10 years.
Yep.
What about that sort of stuff?
I mean, an assessment is basically the equivalent of a betterment, right? So it's a miniature version of a betterment. It's a miniature, like, they got the condo association got the roof fixed. So I look at it on a balance thing. The standard language in the contract says that the seller is going to pay a betterment no matter when it arises between the contract and the closing. So if the day before closing, there's a huge betterment, if I own a 2-unit condo and they're going to redo the roof, now I've got to pay 10 grand for the new roof that they just put on that the buyer is now going to benefit from. So I look at who is going to benefit, right? If it's a late assessment that the buyer is going to benefit from most of it, then I would say that I would put it on the buyer. If it's something that's happened in the past that has increased the value of the unit, I would say that gets put on the seller. But that's another thing. In the standard purchase and sale agreement that comes over, that a lot of people like to put in, it says any assessment put on at any time is the seller's responsibility. And I always try to change that if I'm representing the seller. But yeah, that's something that you, as an agent, you definitely want to be aware of.
I think in that case, no, go ahead, Dennis.
And as a buyer's agent in particular, part of your due diligence should be asking for the minutes of the condo association meetings up to 6 months to a year, whatever, as many as you can possibly get, and review those minutes, because that's going to tell you if there's a possible assessment or betterment coming on.
Yep.
Hey, can I ask, I wanted to ask about the condo. So I know that in the offer, when you make an offer, you always put, review of condo docs or whatever, so the best practice is when you're making an offer for a buyer is that you as the agent should read all of the condo docs to relay all that information to them before they make the offer?
No, I would make it subject to the buyer's.
Oh.
I would say make it subject to make the buyer's obligation subject to a satisfactory review of the condo docs by the buyer, the buyer's lender, and the buyer's attorney. Okay. But you don't necessarily have to put it in the buyer's lender, because the buyer has a financing contingency. And if the buyer's lender doesn't like the condo docs, they're not going to be able to get financing, or it's going to impact the financing. So I would say that, I would lay out the time frame. I would say, the seller is going to provide the buyer with condo docs within 3 days of the acceptance of the offer, and prior to executing a purchase and sale agreement, if there's time, prior to executing a purchase and sale agreement, the buyer and the buyer's attorney will review the condo docs, and if they're satisfactory, then we'll move forward. That's the ideal mechanics. If the purchase and sale agreement is going to happen too fast, then you can do it, maybe 10 days or 3 days from the purchase and sale agreement, but the seller's going to want it done fast.
Yeah, makes sense. Okay.
One more quick condo question, if I could. So sometimes in the condo docs, like I live in a condo, you get the option of paying like the extra fee, the assessment fee for the roofing in 4 increments, and you sell in May and you've paid 1 increment, you have 3 more increments to go. What kind of disclosure does the seller have to do to make that? I mean, is that something they have to fully disclose, even though they will be selling the property and there's 3 more things to come? Or, I mean, how does that typically work?
I think failure to disclose that is grounds for a problem.
Great, thank you.
Yeah.
And I just wanted to circle back. I think the one thing I've learned is that you always sort of want to be the source of the source.
Yeah.
So Margaret, if you had reviewed the condo docs and something had been missing, that liability sort of goes back on you. But if you provide those docs to them and put that onus on them, that's why it's good to be the source of the source.
As of them, the buyer. So I
Correct.
send it over to the buyer and say, here's the condo docs before you make the offer.
Yeah, read it thoroughly. This is on you. It's okay, of course, if you review that, in my opinion, if you review them, but you don't want to be the arbiter of pass or fail. Do you agree, Mike?
Yes, definitely. Yeah, it's up to the buyer. It's the buyer's review.
Donna,
With
that's
that being said too. Oh, Miss, go ahead.
I was just going to say, Donna, that's a great point, and I always put the onus on the buyers. I think I'm probably one of the more diligent agents in the market, but I do say to them, listen, it's up to you to review the condo docs, the rules and regulations. And also, as part of your inspection contingency, go to the town hall and look at the file. Because if there's anything in that file that you might see or not see that would cause you to make a different decision about whether or not you want to buy the property, I don't want to misinterpret any information that might lead you to walk away or to buy it. So you need to interpret the information on yourself. Like, oh, I want to add on a garage, or we want to put in a pool. You have to go to the building department and do your own due diligence. You have to. Because to Mike's point, very early in the call, I can't anticipate what a buyer wants to do with a property over time after they've purchased it, whether I've represented them or the seller. If they want to add on or improve or change or rip out, that's not up to me. I'm selling what is there at that point in time as you see it. That's what I'm selling.
Yeah.
And every buyer is buying the place as is.
Yep.
Yep.
Two things that I'd point out about condos and condo docs. One is just to make sure that the condo docs that you're actually getting or giving are the updated recorded condo docs. You have no idea how often we get condo docs that aren't recorded. And it's just because maybe the sellers, had them, in their house from 15 years ago when they bought their condo, but they're not the condo docs that were recorded. Chances are pretty good that they're the same, but you never know. And if you gave condo docs that weren't recorded as the buyer's agent and the buyer, you accepted them, you're reviewing them and everything looks good, fine. But if you found out that those weren't the docs that were recorded, or if there were some additional docs, bylaws or whatever that were recorded after that, then you could be setting yourself up and your clients up for failure too, right? The other thing is that some attorneys charge for buyer's review and, $500, $600, $700, whatever it is. And some attorneys definitely do skim over that. Mike doesn't, and I'm not just saying that because he's on the call. Mike is somebody who picks up his phone every single time you call, and he's got the one-on-one with the buyers or the sellers. I don't know many attorneys that work the way that he does, and that's true. But with that being said, make sure that your attorney partner is earning their money, because if they're charging your client, their mutual client, for a buyer's representation review fee, make sure it's not just a standard P&S review. They should also be reviewing the condo docs for the clients too. And attorneys are very, 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 very busy right now. And that's probably one of the things that they would skim over if they could. So just make sure that we hold our partners accountable,
Yep.
So back to the condo docs, as what I would recommend is that you get them, that they be gotten from the management company if there is one. So you get you're getting the latest ones. If you're just getting it, let's say if you're on the listing end and you just get it from the seller and say, I got them, you want to make sure that they're giving you the latest ones. Right. Especially the original owners, because chances are there is an amendment. But these days, the price to get condo docs can be, in many cases, is not that much money, because it's all digital now, and it's not. They used to charge quite a bit. It's worth it just to make sure that you got it, and getting it from the powers that may be will have the latest ones.
All right, so sake of time, it's 9:59. Bucher had to run off and jump into another meeting. Does anybody have any burning desires? Anything they want to throw out there at the last minute? All right, guys, great mastermind. Mike, thanks for joining us. Tell all your friends about next Tuesday's mastermind, and we'll see you then.
Thank you. Bye-bye.
Thanks.
Hello, Bob Malone. Did you get in touch with my client?
No, they haven't called yet.
Keep ringing him. She's a postal worker, so she gets in after, dinner hour.
Okay. All right. Yeah, I will. You got it.
Stay on it, man.
Thank you very much. Bye, guys.